Mr. Simmons?
At the beginning of this case, we told you to examine the chain of evidence to determine which is the weakest link in the prosecution's chain of evidence. It's now, we've heard all the testimony, we've seen all the evidence. It's now your duty to take the microscope of truth and separate falsehood from truth. In a few moments, you'll be instructed by the judge as to the basis for making your decision, and you will retire to a room to determine the fate of Tony Grubb. None of us can make the decision that you have been entrusted with this day. Not me, not opposing counsel, not the judge. You have been given a great power to balance the scales of justice. But with great power comes great responsibility. Remember the words of Moses when he was instructing the Israelites in the giving of the law in Deuteronomy. You shall not render an unfair decision. Remember that as you deliberate. Now there's two charges that you will have to determine. First, is Tony Grubb innocent or guilty of burglary? And two, is he innocent or guilty of theft? Now, the prosecution has to prove this beyond a reasonable doubt. Three things before you can find a conviction on burglary. First, that Tony Grubb actually entered Mrs. Stevens' apartment, that he entered it without her consent or permission, and that he entered it with the intent to commit a felony therein. Boiled down, it comes down to one simple question. Was Tony Grubb the man who entered Mrs. Stevens' apartment that night? Now, the prosecution has offered three pieces of circumstantial evidence to prove this, and one eyewitness, Mrs. Stevens. Now, you heard Mrs. Stevens testify how she was in her bed that night, how she heard the sliding glass door open, how she was groggy, she didn't have her glasses on, how she was blinded by the contrast of light when he flipped the switch on in her room. People wear glasses for one reason. They cannot see very well. Mrs. Stevens, unfortunately for us and the prosecution, could not see her assailant clearly enough to give enough detail for a composite sketch, and additionally failed to identify the defendant, Tony Grubb, in a photo pack ID. She was able to give some general characteristics, that the individual was 6 foot, that he was approximately 225 to 230 pounds, and that he was muscular. Now, he also asked her for jewelry, then money, then silverware. Why silverware? And why, when she lied to him, wouldn't he accept that as fact? He insisted that she had silverware in the house. My client has never met Mrs. Stevens before. How would he know that if this was a random burglary? But some of you might say, oh, doesn't matter. The fingerprint. Yeah, the fingerprint. It shows that he was there. That's what some of you might say. Well, let's look at that a little more closely. Mrs. Stevens shopped at the Albertsons that day on Memorial Road, the same Albertsons that Tony Grubb worked at as a supervisor. And let's face it, Albertsons is not your Walmart. They don't have everything there. It's a grocery store. Later that day, Mrs. Stevens took that package and ate one of the chocolate bars, which required her to open the package. Now, later that night, when the burglar came in, He came in, opened the refrigerator door, took one out, and ate the chocolate bar. As has been introduced into evidence, the fingerprint is on the bottom of the Hershey bar wrapper, and the package is open. Ask yourselves, why would he have to reach under to pick up the package when all he had to do was reach in and pull out a candy bar? It doesn't make sense. And even if he did reach in and pull out the candy bar, why aren't there fingerprints on the front of the package as well as the bottom? In fact, why aren't there more fingerprints? The burglar had to open the sliding glass door on her living room. He had to flick the switch on in her bedroom. And he had to open the refrigerator door that night before he ever put a single fingerprint, allegedly, on the package. And yet you heard Officer McIntyre testify that no other fingerprints were found at the scene, no other DNA, nothing. Nothing. The fingerprint actually suggests the truth of Tony Grubb's story, that the fingerprint did come from the stocking of the shelves at Albertsons. And Officer McIntyre additionally testified that prior to July 19th, when they had run the matches initially from the fingerprint and had come up with no fingerprints in the database, he stated they were out of leads. And then suddenly the necklace pops up at a pawn shop. Convenient. With a fingerprint on the tab. Even more convenient. And the fingerprint on the pawn ticket, the right thumbprint, now matches the fingerprints on file. And those fingerprints are determined to match the fingerprint on the candy bar. Why didn't they match in the first place? Some of you might still say, but he had the necklace. Doesn't that prove that he's guilty? Well, the officers searched the house for the silverware and the other jewelry and found nothing. He already told Officer McIntyre how he acquired the necklace, playing pool with Ace Hodges at the Full of Bull pub. The same pub that the grandniece of Alois Stevens dated Ace Hodges. The same place. Additionally, Officer McIntyre testified that Ace Hodges matches the description very, very conveniently, perfectly in fact, that Miss Stevens gave of her burglar. But Tony Grubb, stand up for a minute, will you please? Tony Grubb is only 5 foot 11 inches, 250 pounds, and is not muscular. Ace Hodges has been testified as 6 foot, 230 pounds, and muscular. Perfect fit. But think of this. You heard Mrs. Stevens testify that she heard a noise, and before she could move, before she could get out of bed to investigate, the burglar was in her doorway. Yes, Tony Grubb has a prior conviction from the same apartment complex, but nothing has been introduced in the evidence to show that he knew Mrs. Stevens' apartment, that the apartments are the same, that the ones that he prior burglarized 13 years ago. But Ace Hodges, who has already been over there and already knew about the silver, according to the grandniece, would have known the layout. And the burglar knows to come through the sliding glass door and knows which of the bedrooms to go to. There's 2 bedrooms. He knows to go to the right one, the one where Mrs. Stevens is. That's something that my client, Tony Grubb, having never met Mrs. Stevens, would not know how to do. Finally, with regard to theft, before you can find a conviction for him knowingly and intentionally depriving Mrs. Stevens of her property, the value has to be $300. As the judge will later instruct, the jury instructions require that the value be at the time or occurrence of the event and that they be the market value of the property. Tony Grubb was only able to get $200 or less for the necklace, which is below the requirement of the statute. We have been fair and truthful in presenting Tony Grubb's case. The prosecution's chain of evidence is weak, and in fact seems to be held together with paper clips. Examined under the microscope of truth, examine it please, under the microscope of truth, determine that these are paper clips that link these chains of circumstantial evidence together, and break them and set Tony Grubb free.